Testing, 1, 2, 3. Testing, testing, 1, 2, 3. Testing, testing. Getting ready for the meeting with Mr. John Anthony Castro. And you guys might remember we actually had some time to speak with Mr. Castro. I'm going to share my screen as we get ready for Mr. Castro. We're actually doing the Castro V Trump series starting today. We've actually done quite a few shows talking about Mr. John Anthony Castro, his candidacy, and the case, his filing. But what I'm going to be sharing, I'm going to share my screen. Because I want to bring up. Today we want to get into the case some more, and we're going to do a new series, a new podcast series. It's going to be the Castro V Trump series, because it hasn't been getting a lot of coverage. And I think I got a question from one of our viewers asking about the coverage. Why is it that a lot of news media people not covering this? And I think that Mr. Castro did respond, but people are still looking for some more responses. Let's close this. Okay, this will stay open. I need this one to be open. And there we go. Actually, getting ready. I'm actually tweeting something about this. Getting ready for the Castro V Trump series featuring at on the Neoliberal round. HTTPS anchor.fm/the Neoliberal. Oops, let's fix this. There we go. Oh, it's working, Renaldo. No, we are not advertising that. No, I need to bring up Mr.
Case number 1:22-CV-021. So on Monday, July 25th, this past Monday, I filed this case in Washington, D.C. before the United States District Court for the District of Columbia. You'll see it right here, John Anthony Castro. That's a business address, so I'm not concerned. Versus the Federal Election Commission. You'll see the case, I'm trying to look at the camera, right here. It's case number 1:22-CV-02176, jury demand. The judge assigned to the case was Rudolph Contreras, and it's a jury demand case. So what is this case? What does it mean? Why do I think it's going to be successful? Who the hell is this guy anyways? And it's all that. So that's what this video is all about. I want to give you some background. So first, my name is John Anthony Castro. I have been an anti-Trump Republican pretty much since Trump announced that he was going to run for the presidency. I, like a lot of people, were completely blindsided when he actually won the election, and spent most of 2017 wondering what I was going to try to do about it. And at that time, I had a tax law firm, Castro & Company, that had really just taken off. And it was quite unexpected, but it was generating several $1 million a year, my tax law practice. And I'll just be honest, I was a little bit scared about kind of messing up a good thing. You know, I was like, do I do I come out against him? And then, what happens if people don't like that and they don't come to my firm anymore? And there's all those considerations. And I went through a period of self-indulgence, and I don't want to say these things right now, right? That way I get them out, but people won't use it against me later to judge me. But I did buy like a Ferrari, and I bought a lot of nice clothing, and Rolex watch, and all that stuff. I was born into a poor family, so all of a sudden, making it and having a very successful firm generating millions of dollars, totally unexpected. But it was in 2017 when I was like, something has to be done about this, especially with the Charlottesville and all that stuff. I was like, no, I can't stay by idly quiet. And I became part of a group. Actually, I started a group. And, I coined it after the French Resistance movement. And we got very active with Roy Moore in Alabama. And I probably spent north of $150,000 of my own money to stop Roy Moore in Alabama. And when we were successful, I think it was that point when it really got to our head that, wow, like if we can flip Alabama, there's nothing that's off the table. Not even Georgia, which obviously we saw how that went 2 years later in 2020. So that being said, that's who I am. In 2020, I ran for U.S. Senate against John Cornyn in the state of Texas. I ran on the Republican ticket. I tried to stick to the issues, because of all the culture war BS and all that. I was really trying to stick to the issues, and I was really trying to show people what true conservatism is about. Limited government in the sense that we don't care if you're LGBTQ. We don't care if you want to marry somebody of the same gender. We don't care if your doctor prescribes you THC. You know what I mean? Like small, limited federal government, period. Stay out of our personal lives. And that's basically goes back to Barry Goldwater conservatism. Sorry, I had a low battery notice. I had to clear the screen. That all goes back to Barry Goldwater, Conscience of a Conservative, from the early 1960s. Only true conservatives actually know that, because again, like I've actually studied conservative political philosophy. But that being said, I ended up linking up with the Lincoln Project and other like-minded people to get really involved after the whole Roy Moore victory. And in 2020, I probably spent north of $250,000 of my own money to make sure. And my states that I focused on was Michigan, Wisconsin, and Pennsylvania. My personal analysis and conclusion was that if Trump didn't carry those states, that there was no way he could win the presidency. And then even there on a more granular level, we focused on the counties that were flippable, and even within those counties, the neighborhoods that were kind of like the swing neighborhoods. So that being said, a lot of background,
Good afternoon. Hey, how are you?
Can you hear me now?
I can. How are you? Good evening. How are you?
Good. Let me just change the background here real quick. There we go.
Oh, nice. Love it. Beautiful. Good evening. How are you doing, John?
Good. It was as you can see the way I'm dressed, it was just a regular work day.
I love it.
Yeah.
I love that. I love that attire. It's nice. So that's it. That's what you call it. GQ. That's the post-millennial. I like it. That is good. And you got style. And Mr. John Anthony Castro, the U.S. 2024 presidential candidate, has style, and that's good. That is good. Welcome to another episode, and let's do the official welcome. Welcome to the Castro V Trump series, and we have with us none other than the person who is featured and the star of this new episode series that we will be doing, where we try to give you an update as to what's going on regarding the Castro v Trump trial or case. And we have with us Mr. John Anthony Castro, who is the main plaintiff of the Castro v Trump trial or case, is it? And he's with us. He's running for president, and we are happy to have him. And just so you know, we've had several shows, and several people have been sending me emails, Twitter comments, messages, YouTube comments. They want to know what is going on. They want to know what's going on with the case, and we've been talking about it. But just so you know, we want to know about the case a little bit more. The case started on July 25th, 2022, but that was when you filed the lawsuit in the District of Columbia, DC, against the FEC to have Trump declared ineligible to run in 2024 under Section 3 of the 14th Amendment for his part in January 6th insurrection. And for those of us who don't know what Section 3 of the 14th Amendment is, can you give us some details about that? And give us a little bit detail, a timeline as to what from July 25th up to now.
Yeah, absolutely. Yeah, so it's best to start from the beginning because it's really important to understand this. So for the viewers that went to law school, it's going to feel like a law class. For those that didn't, get ready. This is what a law class feels like.
All right.
So
yes.
It's the 1860s and America is at civil war, and the Confederacy is beginning to lose, and things are getting really bad. And the Confederates are trying to figure out a way, like, okay, how do we surrender? Like, we need to recognize we've been defeated. The Union, is just superior in military machinery and in order, everything. So, long story short is Jefferson Davis is the president at that time of the Confederacy, and so he goes ahead and he pretty much negotiates the surrender. So part of that surrender was, of course, the adoption and ratification of the 13th Amendment, which abolished slavery, and the adoption of the 14th Amendment. There was 5 parts to the 14th Amendment. The most notable is going to be Part 1. Part 1 had to do with equal protection, right? So you can't discriminate against people anymore based on the color of their skin or their prior indentured servitude status. So pretty much former slaves. And then there was Section 2 had to do, and 4 had to do with public debt and some other random things. Section 5 was an enforcement mechanism for Section 1, basically said that Congress can pass all necessary and proper laws to enforce equality, right? So that's why they call it the necessary and proper clause. And then there was Section 3. Section 3 said, if you fought for the Confederacy, you're pretty much banned for life from holding public office because you fought in a rebellion or in an insurrection against the established authority of the United States government. So with that being said, what the goal of Section 3 of the 14th Amendment is it basically allowed the Union to come in and completely take over the entire infrastructure, the power structure of all the southern states. So, for example, in Alabama and Mississippi, if you fought for the Confederacy in any way, shape, or form, even just expressing support, and waving the Confederate flag, you could not hold public office. You couldn't be even elected to city council. So what ended up happening is all these Northerners, all these Unionists moved down to the South and basically became like military occupiers. They took over city councils, county commissioners, they took over the state legislature, the Supreme Court, the governorship, everything. So imagine today if the Democratic Party had the power to appoint Alexandria Ocasio-Cortez as governor of Alabama.
Yeah.
You know what I mean? Like it would be startling, right? All of a sudden, Senator Elizabeth Warren becomes your lieutenant governor, and it's going to freak everybody out, right? Because number one, that doesn't even align with their political views, and number two, they are viewed as basically foreign occupiers, right? They're from the North that they were at war with, and so the South didn't have a choice at this point, right? Let's just be blunt, they were getting their asses handed to them. They had to surrender. And so they basically said, look, we lost. That's how war works. So tough. So they signed. Now, as part of that surrender, of course, they gave up all political power, but there were a lot of Confederates in the South that were not happy with this. They just felt like it was military occupation, which in every sense of the term, it was military occupation. The Union came in, took over everything. And so they had absolutely zero political power, zero military power, and completely occupied. At the same time, they put Jefferson Davis on trial for treason, right? He was the president of the Confederacy, waged war against his brothers in the North, and it was time that he fessed up to his crimes of treason against the United States government. Well, at that time, in 1869, when he was standing trial for this, his lawyer came up with a really good argument, and it was actually accurate. His lawyer said, well, wait a minute. Section 3 of the 14th Amendment says that if you wage war against your own government, through rebellion or insurrection, you're banned from public office. That's already a punishment. So to charge him criminally with treason would violate the double jeopardy rule. Double jeopardy basically says that if you've already been punished for a particular commission of a transgression, that you can't be punished again, right? You can't be placed twice for life or liberty. And so that was the argument, that would violate the double jeopardy clause, because what Section 3 of the 14th Amendment effectively did was it reduced insurrection to a political crime. And so it shielded you from criminal prosecution, but you were banned from public office for life. Okay. So at that time, United States Supreme Court Chief Justice Salmon P. Chase took a look at that argument and said, you know what? He's right. It would actually violate double jeopardy. And so he dismissed the criminal charges for treason against Jefferson Davis. But the agreement at that time, Jefferson Davis agreed. And he said, yep, I agree 100%. I am banned from holding public office for life. I can't even be elected to city council. Yeah. So he accepted that as his fate. Now, shortly after that, there was a lot of anger brewing in the South about this whole, you can't hold public office for life, right? And some of them were waiting for their teenage kids to turn 18 so they could run for office and try to reclaim some of these seats, but they were starting to get really, really agitated. So at that time, the president decided, and this was after, of course, Lincoln's assassination and everything, the president at that time decided, you know what, for the good of the country, there's a lot of talk about a second civil war brewing, and it was a legitimate, incredible threat. There was about to be just the boiling was there. We were about to go into a second civil war because they couldn't accept the fact that they had zero political power. So the president at the time deciding, and his argument was for the good of the nation, to heal the nation and bring the nation together again, we cannot treat our Confederate brothers as second-class citizens, and we cannot strip them of the power to hold public office. Everybody in the South at that time, it was just considered common in their culture that they supported and waved the Confederate flag, many of them not knowing what it even meant. And so it would be unfair to ban all of them from public office for the rest of their lives. And it's going to effectively create second-class citizens in the South, and it's not going to foster the healing of our nation and what we just went through. So on that basis, he decided to grant amnesty to everybody that fought for the Confederacy. And like that, the Confederates took over the South again. And of course, the South became racist again. I mean, not that Unionists and Northerners weren't racist, but, to obviously a substantially less degree. And for the most part, it wasn't really about racism at the time. It was more about let's just let's not have slavery, pretty much. That was just like the starting point. So, and then of course we had the 14th Amendment. So we figured, hey, Congress can still Section 5 enforce Section 1. And if we catch you guys doing anything, we're going to try to hold you accountable. And there started the 150-year battle of trying to make sure that Black Americans in the South were simply treated the same as anybody else. And we've been fighting that fight for 150 years. They tried first to make sure that they couldn't vote. They never said you can't vote, but if you showed up, you'd have a burning cross on your front lawn the next day. They'd beat up your kids on their way to school. All kinds of stuff, right? All of a sudden lynch, because you voted. So it had a chilling effect. And of course, we passed a lot of the North passed a lot of laws basically saying, hey, we catch you doing stuff like this, you're going to prison for life. But obviously culminated in the 1964 March on Washington, led by Martin Luther King. And of course, they passed all that. So the rest is history. So Section 3 of the 14th Amendment sat there dormant for over 100 years. It just sat there. And everybody, I mean, we never thought about it, right? Because there's never going to be another rebellion. There's never going to be an insurrection against the United States government.
Yes.
And so before I get into that topic, I want to discuss one thing. which
Yeah.
when I first started looking into this issue, because I love watching news from both sides. I'll watch MSNBC for 1 hour, and then I'll watch Fox News for 1 hour.
And I
because
do
I
the
want to
very
see what
same
both sides
thing.
say.
That is true.
And I want to see where's the disconnect. And then, of course, I like going to the middle of the road, the Associated Press and Reuters, right? Just pure facts. I just give me the facts. I don't want to hear opinion. So what I saw on Fox News is a lot of comparison to, why aren't the BLM protesters banned from public office, right? I mean, they were tipping cars, burning buildings, stomping on police cars. Why is that not an insurrection? So I would like to draw a distinguishment between what an insurrection is and what a riot is.
Yes.
In the words of both Martin Luther King, a lot of people have said that. Martin Luther King said it. Malcolm X said it. Riot is the speech that we see with our eyes when the voiceless are tired of being unheard.
Yeah. And
so it's that frustration that it's to a certain degree, it's an incoherent act of violence, right? In the 1995 LA riots, or whatever year it was, or the mid 90s and the riots, a lot of people were correct to point out, like, 80% of all the businesses burned were Black-owned businesses. How does that make any sense? Well, that proves the point that they didn't know what was wrong with the system. They just knew, why am I being treated differently for the color of my skin? And they were frustrated, and they just finally lashed out. And the fact that they attacked Black-owned businesses is proof that they didn't have a plan, right? Like, they were just angry and frustrated. Same in the 60s in Watts, like all the businesses looted were Black-owned businesses. But again, it had nothing to do with that, right? I mean, because they weren't racist. They weren't trying to attack white-only businesses. They were just frustrated. Like, why am I being treated differently simply because I have more melanin in my skin? It doesn't make any sense. And so, but the difference between a riot and an insurrection is simply that an insurrection is more organized. They have a very particular goal in mind. And that goal is trying to undermine the foundations of our democracy, including the certification of Biden's victory. So as we now know in the whole Dominion v. Fox News lawsuit, is that Tucker Carlson, Fox News, and Sean Hannity knew the election claims were bullshit. They knew it was a lie. And Tucker Carlson texted Janine, whatever the hell her name is, I forgot what it is. He texted her and says, "Excuse me, I just caught Sidney Austin lying to my face."
Wow.
And so he basically says, like, "Hey, look, I just caught them lying to my face, and like, what am I supposed to do?" And then literally 5 minutes later, the cameras turn on, and there he is, basically spouting the same lies as before. So it's pretty crazy, but that's.
But it seems that I don't think. But it seems like the Fox doesn't really. When you the news recently about Tucker Carlson and what he said about Donald Trump in private as against what he's saying in public, it's not matching up. In public, he seemed to be supporting Donald Trump and denouncing the BLM, but in private, he seemed to be saying something else, something opposite. Yeah. So exactly. What is going on at Fox News?
Yeah, exactly. So, but see, that's the difference between a general riot and an insurrection. Is that insurrection was sorry, I have an issue with my light here. An insurrection has an unlawful and well-organized political goal. Okay. And see, the way that we established that it was an insurrection, not just your general riot, is with the conviction of Ben Rhodes. He was the leader of the Oath Keepers. And now they're going after Enrique Torres, the leader of the Proud Boys. And they've already now established seditious conspiracy. Sedition and insurrection, they're synonymous. And if you check a dictionary, they're exactly the same. Rebellion, insurrection, sedition, it's all exactly the same. So Ben Rhodes has been convicted of conspiracy to commit an insurrection. That's basically conspiracy to commit a riot that has a very targeted and well-organized political goal to undermine the nation's democracy. That's the difference. And so now that with the Ben Rhodes conviction, Now with the Ben Rhodes conviction, there's no question. January 6th was an insurrection. Now we also know there was communication between the White House and members of the Oath Keepers and Proud Boys. We still don't know who and why, because Trump is asserting executive privilege. And to a certain degree, that's so everybody's confused about his claim for privilege, right? Because the executive privilege claim is viewed as absolute, but it's not absolute. It's the same as attorney-client privilege, right? Like I can advise somebody on the law, and my advice is covered by the attorney-client privilege, but not if I advise them on how to break the law, right? Like if I'm like an attorney for a mob boss, and I'm telling them like, hey, this is how you kill somebody and get away with it, and this is how you commit tax evasion, I'm going to prison, right? Like, and they can get around the attorney-client privilege because it's called the crime fraud exception. Crime fraud exception. That's really important because the crime fraud exception is recognized in every claim of privilege, spousal privilege, priest privilege, whatever it is. You cannot hide a crime or fraud behind a claim of privilege. And the same applies to the executive privilege, but that has not been settled yet, right? So we have to litigate 18 to 24 months to resolve that issue before we can get around Trump's claim of executive privilege. But we don't even need that right now because we're not trying to prove that Trump engaged in the insurrection, right? Which would require more evidence. Section 3 of the 14th Amendment says you merely have to provide aid or comfort.
Yes.
Comfort is a much lower threshold. That's already been resolved by the Supreme Court. They asked what constitutes aid or comfort, and they said words of affirmation. If you simply said like, oh, I feel really bad for those guys, you know, like they're being treated really badly, and you know, I kind of sympathize with their cause and their situation. Bam, Section 3 of the 14th Amendment kicks in, you're banned from holding public office. But it doesn't apply to ordinary citizens. So like if an ordinary citizen, because the way it works is Section 3 of the 14th Amendment says that if you've ever given an oath to defend the Constitution, so that would mean prior military, anybody that's ever held public office, if you did, or if you were an elected politician at the time that you expressed those words of support, then you're done. And that would apply especially to Marjorie Taylor Greene, right? She's going around over there hugging the January 6 people, making it seem like they're political prisoners. You're gone. But nobody knows how to enforce Section 3 of the 14th Amendment. That's the problem. And so when this came up, I immediately started doing legal research, right? Because I love going down the rabbit hole on these types of constitutional issues. So that's when I found the Jefferson Davis case. There was also the case where, well, there's some history behind it, but when at a point in time, the predecessor to DOJ, Congress passed an enabling law that allowed the what was effectively at that time the U.S. Department of Justice to go after people that were holding public office in violation of Section 3. But they passed enabling legislation to tag on criminal charges. And so they ended up actually going after they removed the entire Tennessee Supreme Court. And this was back in 1869. They brought criminal charges against the entire Tennessee Supreme Court because they were all Confederates. They kicked them all off and replaced them all with Unionists. And so, but see, at that time, the reason there was back and forth is because nobody knew, is Section 3 of the 14th Amendment self-executing? Self-executing means it automatically applies by operation of law. You don't have to pass any enabling legislation to back it up. Well, Jefferson Davis said that it was self-executing, and that was the whole basis for his treason criminal charges being dismissed. But now all of a sudden the Supreme Court started backtracking on that and saying, well, hold on a minute. Maybe it's not self-executing. It's just like, all right, come on, guys. You can't have it both ways. Like you already ruled this in 1869. How are you going to completely backpedal only 3 years later in 1872, right? That would be the most intellectually dishonest Supreme Court ruling in United States history. And it simply was. Chief Justice Salmon P. Chase first ruled in Jefferson Davis's case that it was self-executing to shield him from criminal prosecution, and then later reversed that in a separate case and said, I don't think it's self-executing anymore. But of course, how convenient now that, of course, amnesty has been passed. You don't really need Section 3 of the 14th Amendment anymore. And, you know, DOJ had already been given the enabling legislation to, on their own, bring criminal charges against violators, you know, previously. So long story short is this just sat there, like, again, for about 150 years until this day. And Trump is on television saying, we love you. You're very special people. And this is after watching for 180 minutes, 3 hours, him watching on television, them breaking windows,
Yes.
taking a crap on Nancy Pelosi's desk,
Yes.
looting Congress, but when you see it in Hurricane Katrina, you see people walking around with television, they're looters. You see a white guy walking in Congress holding the speakers thing. It's just like, oh, he's smiling, he's waving, he's just a nice guy. No, they're looting. That's what they were doing. They were looting, they were pillaging, they were rampaging through and ransacking our United States Capitol. And all of them, every single one of them, if they've ever served in the military or if they've ever held public office, they are banned for life from public office. And after I'm done with Trump, I'm going after everybody. Now I'm starting a political action committee that's going to basically be Nuremberg trials. Like, I'm going to hunt down every single person that was there, every person that violated an oath of office that they previously took, and I'm going to make sure that they are not even elected to city council in this country. If they'd like, they can move to another country. So, but first things first is going after Trump, holding him accountable. That's going to be the most important thing. And so that's what the Trump v. lawsuit or Castro v. Trump lawsuit is all about. Now
that one you filed on, was it January 6th?
Yes, and that was very intentional. I waited specifically to January 6, 2023, the 2-year anniversary of the attack on the United States Capitol, and I filed a lawsuit. The first thing that and then of course randomly, Judge Eileen Cannon was assigned to the case. For those unfamiliar, Judge Eileen Cannon is the federal judge that interfered and tried to shut down the FBI's criminal investigation into Donald Trump. That was later overturned by the United States Court of Appeals for the 11th Circuit. They found that her intervention violated the Constitution's separation of powers principle, so it was an unconstitutional act. They also viewed it as an abuse of her discretion, so it was both abusive and unconstitutional. And it showed
and that was on a different case.
Yeah, that was back when the FBI raided, or not raided, I take that back. It wasn't a raid. When the FBI searched Mar-a-Lago for top secret documents that Trump was clearly possessing and trying to hide from them. So they went in there, they searched the place, they found documents. So, and then of course Trump tried to say like, oh, they planted it. And it's just like, dude, no, they didn't. It was very clear from all the affidavits that Trump had been intentionally hiding those documents in a particular area. The FBI was aware of it. They were basically trying to figure out, why is he doing this? What is he trying to hide? It doesn't make any sense. It was very clear that he had the mental state. They already have the email where he specifically told the attorney, don't let him see this room. And later, when the FBI searched that room, that's where they found those documents. So it's very clear that they were hiding those documents there. But we still don't know what the content of those documents were, or like why Trump was obsessed with trying to keep them. It may have been just something stupid like a memento, something with his ego, or it could have been worse. I don't know. But I do know he held a golf event 1 week before the FBI went onto the property, and there was a ton of Saudi officials there, Saudi government officials. So all we know, we don't know if he sold those documents, or allowed somebody to go in after hours, turn off the cameras. They got to read those documents and get intel on, Israel's nuclear capabilities. We have no idea, but we do know that that Saudi officials were there and those areas were compromised. So that being said, that's what the Castro v. Trump lawsuit is all about. Now, I filed the case.
And for those persons who are following you, it's different from the case that you filed on the 25th. And that case is no longer that's no longer before the court, correct?
Correct. Oh, well, yeah. So, you're right. Let me go back in time. So we're going to pause real quick. I filed January 6, 2023 against Trump, but there was a case before that I had been working on. So before that, last year, we all knew that Trump was running for president, right? He was going around from rally to rally to rally. He couldn't stop going to freaking rallies. There are thousands of people. The signs say Trump 2024. He's asking people to donate to his 2024 campaign. I mean, he was running, right? We all know that. And it was frustrating me because the regulations, the way they're written, it's not right. They don't enforce it properly. And so I was suing the Federal Election Commission to have Trump declared a candidate because I wanted to subject him to scrutiny, because when you are a declared candidate, there's a lot more reporting requirements. So I sued the Federal Election Commission. First, I filed a complaint against Trump with the Federal Election Commission, basically said, hey, look, he's running for presidency. And not only that, he needs to be declared a candidate. After he's declared a candidate, I want his FEC Form 2 rejected because he's an ineligible candidate. And by submitting the FEC Form 2, he's basically committing federal perjury. He's lying on a document saying that he's a viable candidate, and he's not. So, and then also argued that the FEC's acceptance of that would contravene Section 3 of the 14th Amendment and be an unconstitutional act that under the Administrative Procedures Act that the court could file an injunction, basically prevent them from doing that. So basically shut down his campaign's ability to raise campaign funds. The federal judge in that case, he ruled that I didn't have standing. There's three elements to standing. If you're going to sue someone in federal court, you have to say, I was injured. This is the person that injured me. And this is what the court can do to remedy my harm.
Right.
And so those are the very simplified version, but that's basically the three elements of standing in order to bring a suit. So a lot of people say, hey, I'm a voter. How come I can't sue Trump? Well, because you're not directly being harmed, right? Like you have a generalized harm that every voter shares. But what's your particularized harm? If you're a fellow primary candidate, your particularized harm is he's taking away votes from me. So a fellow primary candidate has a direct harm, right? He's taking votes, he's taking donors away from me. So that was my argument for standing. It's just that, but my case was a little bit unique. I said that the FEC is the one that's harming me because they're letting him raise funds.
Yeah.
And I'm being harmed in the sense that I'm losing access to potential donors because obviously, he has a stranglehold on all the GOP donor base. Yeah. And so the judge didn't buy that argument. And he basically said, no, he said the FEC only has the power to regulate campaign finances, not to determine eligibility. But that's not necessarily true. There's a way to interpret the definition of candidate under the Federal Election Campaign Act. But I will say that I can see some judges being convinced, but I could probably convince 3 judges on the Supreme Court, but I think 6 judges will ultimately probably disagree with me. But nevertheless, there's a viable argument, so I'm going to pursue it. So right now that case is on appeal before the United States Court of Appeals for the DC Circuit. Yeah. And they're going to determine whether or not the definition of candidate can be interpreted that way, which it can, but it would also give an executive agency a brand new power they've never really had before. Yeah. And so I can see how the conservative wing of the federal judiciary is not keen on expanding agency powers. They're about reining in the federal bureaucracy, not expanding it. So again,
but, I think but you know what I found quite interesting though is the response. You said that they said that the FEC does not, the FEC's role is just to regulate financing, but then doesn't that affect their ability? Because we thought that it was more than just regulating financing. That means they can't do anything else outside of regulating finances.
Yeah, that's basically what they're saying is they're basically, FEC's like, hey, we're just basically the referees for finance. That's it. We just make sure everybody follows the rules, but we can't get into the business of saying who is and isn't eligible to run for office. Okay. So they claim, right? And and like I said, ultimately, if I had to do a political judicial analysis, I would say that it's going to be a 6-3 decision against me. That's just me being intellectually honest. But I want to have that issue settled. That way it's case law and it's no longer a question. So now that we identified that basically, that was not a viable route, now it's the Castro V Trump lawsuit. This one is me directly against Donald Trump. Yeah, he injured me because he's taking away votes, or I was injured, in the sense of political, what they call reduction in votes and donors. Donald Trump is the one that is causing the injury through his unlawful and unconstitutional candidacy. And the court can remedy this by declaring that he is ineligible, which will then give me a federal judgment that I can take to state court and then enforce the state election authorities to kick him off the ballot. So that's the game plan right now. And so right now, Trump and his lawyers at first, I think they dismissed this as like this guy's just like, looking for his 15 minutes of fame. He's a political nobody. We're going to squash him in court. What they fail to realize is number one, I'm a legal strategist and I know the Constitution and the federal rules like the back of my hand. When you file a motion to dismiss a lawsuit, anything in the complaint, anything that's stated as a fact has to be accepted as true. It has to be accepted as true. So if I say that I'm a candidate and I'm running for office, I'm a candidate and running for office, period. And so they've tried to attack my candidacy to say that, oh, he's not a bona fide candidate. First of all, that's ridiculous. But I still responded, right? Just to humor them.
And let me just interrupt, because I actually read and you said did he file the motion to dismiss on the 16th and on the 3rd and on the 2nd? Or was it just one motion? Did he file?
No. So So what they do first is they file a motion to dismiss, and then that's when we responded with a very comprehensive reply brief. And it was also a verified reply. The reason it was verified is because that transforms all of the statements of fact into admissible evidence, which then again boxes in the judge, because now anything stated in the reply brief now forms a part of the factual record. They still haven't realized this yet, and I think they're slowly realizing the legal ingenuity behind the filings, but that's when they freaked out. And then of course they tried to attack the bona fides, so I responded just again to humor them, even though I know I didn't need to. But I basically pointed out the fact that she pointed out in her motion to dismiss that, oh, he's been trying to get Trump kicked off, or declared ineligible since last year. And I'm like, oh, thanks for making it clear that I've effectively been running for office for more than a year now. So there was that admission on her part. And then what was it?
Because I know you responded on the 28th. So he filed on the 16th. He filed a motion to dismiss on the 16th. Then on the 22nd of February, there was a writ of mandamus to remove Judge Aileen Cannon. And then on the 28th,
so I'll walk you through the timeline. So the first thing we did is I requested access to e-filing. I can electronically file in multiple jurisdictions in this country, right? It's not a problem. But she said, oh, well, you're not a Florida licensed attorney, and therefore I'm not granting you the right to electronically file. I mean, it's kind of a pain in the ass, because now I have to pay a runner to go there all the time and pay for file. But it's just this pettiness, right? So what she doesn't realize is any limitation on your First Amendment right to petition the federal judiciary to redress your grievances in an efficient manner is considered a violation of the First Amendment. So I let her know right away, I'm not messing around. Filed a writ of mandamus before the First Circuit. I said her denial to allow me to e-file is a violation of my First Amendment right. Then I motioned to recuse. I said, hey, you need to be taken off the case. You've already expressed bias. Then she denied that too. So within 24 hours, I had a writ of mandamus before the United States Court of Appeals for the 11th Circuit. So at that point, they realized, this guy's not messing around. As fast as we deny his stuff, he's going to have this before the appellate court. And same warning to the 11th Circuit. I've already told them, you guys deny it, it's writ of certiorari to the U.S. Supreme Court. I am going to fast track this to the Supreme Court. And so right now, then, of course, they filed the motion to dismiss. I replied. And then at the same time, I also filed an emergency motion to stay the proceedings. So I asked the 11th Circuit to basically order her to stand down until that case is resolved. A whole week passed, and we didn't hear from them. We filed that last Monday. On Friday, though, Jim Trusty, which is another one of Trump's lawyers, you can just type in Jim Trusty in Google, Jim Trusty Trump, and you'll see all about him. Basically, he's the partner at IFRA Law. He submitted a notice of appearance in both the writs of mandamus cases. Yeah, and so it's very clear at this point.
Is that unusual for them to do that, or they?
Well, I would say this: if they were confident that the writ was just going to be summarily rejected by the 11th Circuit, he wouldn't have submitted a notice of appearance. He did that because there has to be an indication at this point that the court hasn't denied it, right? So I'm seeing it as the glass half empty, which is, hey, it's been a week and the appellate judge hasn't approved it, right? But Jim Trusty's also seeing it from his perspective. He's like, oh, a week has passed and they haven't denied it. That looks bad too. So we don't know what the 11th Circuit is doing.
And that's the writ of mandamus, right?
Yeah. So that would be the two cases where am I entitled to electronically filing, and should Aileen Cannon be kicked off the case? And so my guess is that.
What is the importance to electronic? What is the importance of electronically filing to the case? How is it important?
It's just easier after I finish. Let's say the brief is due today, and it's due at 9 p.m. Or it's closed. It's due at the end of business. I can e-file at 10:59 p.m. Central Time, which is 11:59 p.m. Eastern Time, and it would be considered timely. But if I have to paper file, I have to have it done the day before, have it printed, have it sent to a court runner. So I have to then email it to a court runner. I have to pay them $50 to run down to the federal courthouse, go to the third floor, and then actually file it in person there.
Oh, wow.
And that's assuming they get there in time. You know what I mean?
Yeah.
And so it runs the risk that you could miss deadlines and stuff like that. And they know that. They know that. So they want to make it hard, right? And so they want to make it hard. They want to make it difficult. But that's why we've been very quick and very fast to file anything. It's my way of telling Judge Eileen Ken, you're not going to stop this. There's nothing you can do because I'm ready. And we have 3 runners on standby. So anytime that we give any document to one runner, we already have another runner on queue as backup.
Yes.
So
yes.
we're ready to go.
Nice.
They don't realize, like, I'm not messing around. Like when I
Yes.
engage, you know, those that know my background know that I'm a West Point dropout. But my father was 20 years special forces, and I've had a lot of military training. I know exactly what I'm doing. And when I decide to engage, it's not to play around. I'm here to retire Trump permanently. So that being said, you know, she refused to recuse. They filed a motion to dismiss. I filed a reply brief, and that's where I humored her argument that I wasn't a bona fide candidate. I basically pointed out, like, hey, look, you know, I ran for Senate, I ran for Congress as a Republican. Nobody ever questioned that I was a Republican. But now that I'm running for president challenging Trump, they're like, oh, who's this guy? He's a rhino, you know. And they don't realize, like, I've literally studied conservative political philosophy. If there's anyone that's literally qualified to teach a class on conservative political philosophy, it's me. And I can definitively tell you that today's Republican Party does not represent conservative political philosophy. They're big government. They want to encroach into your personal privacy. And that, ladies and gentlemen, is fascism. That's what it is. They put on this mask of fake Christianity, and they use that as the guise to push some of their fascist ideology. But if you look at what they're actually doing, they're trying to expand the power of the executive branch. They're trying to expand the power of the federal government. They're trying to create new powers for U.S. intelligence agencies to spy on Americans. I mean, these are big government fascists. They are not. They are not your grandparents and your parents' Republicans. So I recognize that, right, as a student of conservative political philosophy, and as a teacher of conservative political philosophy. But I'm not going to try to explain that to, you know, these Trump mass ballots. So you know, they're going to believe whatever they want to believe. I mean, they believe that Democrats are like Satan worshiping pedophiles, right? I mean, there's no talking to people. They're completely low IQ, brain dead people. So that's where we are now.
And I have some questions. I know there's one more thing. So I might ask you some point by point question, because as I said, I read the motion. Let's say Donald Trump is challenging you on these 4 things or 5 things. He's challenging you. He's saying that 1, the court lacks jurisdiction. 2, that you lack, and then I think he referenced or cited William V. Pouch. So I'm going to ask you about that. And 2, he says you lack standing. And then 3, he says even if you do not lack standing, you lack rightness. And then 4th, and then he says, how many states? Then he said that you're not registered in a lot. You're only registered in just a few states and a lot of states.
Yeah, well, that's the hilarious part. Yeah, I'll get into that.
And then finally, he says that you have not distinguished yourself from the public. So those are some of the 4 things I garnered from the motion. Would you like to respond to each of those? Yeah,
absolutely. Right. So it was all in my reply brief. But basically, where he says I don't have standing is. You can tell that the attorneys are not well versed in political competitor standing, because this has only been recognized, and rightfully so, in the United States Court of Appeals for the D.C. Circuit, because that's where all these issues come up, right, with the FEC and you know, political issues. But political competitor standing basically says that a political competitor automatically has a de jure injury, because if I'm competing against you for votes, clearly I'm going to suffer a diminution, which is just a fancy word for a reduction in votes, right? You're going to take votes away from me. And it doesn't matter if it's 1 vote or 1,000,000 votes. If you take 1 vote away from me, I have an injury, right? I mean, it's not like I have to have a punch in the face. You know, even if you slap me with 1 finger, it's an injury. And so they're trying to focus on that part. But like I said, anything stated in the complaint has to be accepted as true if it's a factual statement. I've already said I'm running for office. I've already said that I've spoken with people that said they would support me if and only if Trump was not on the ballot, which is a true statement. And so, and it was verified. That was actually verified under penalties of perjury, which is, makes it an admissible fact. So, and that's not even technically required. That's only required if you're seeking a temporary restraining order, which we will later. But that being said, that argument basically falls because they're trying to argue ripeness in that we're not in a primary, right? So I'm not losing votes yet. And it's just kind of like, oh my God, you don't have to wait until it's an actual primary election, right? Because then it's a non-justiciable issue because you have an ongoing election. So right now there's a competition for political support of would-be voters. And that in and of itself is enough to suffice. So this has already been settled by the United States Court of Appeals for the DC Circuit, and they tried to challenge it. The Supreme Court basically rejected it, which is basically them saying we agree with that. So that issue is dead. So their standing issue is out the window. The ripeness issue is out the window. Both of those go out the window together, right? Because anything stated in the complaint has to be accepted as true for purposes of the dismissal. So I win on that issue. So the next thing he's trying to say is he hasn't stated a claim upon which relief can be granted. Now, his argument there is that normally in order to bring a cause of action in federal court, you have to cite first what your constitutional authority is. And then after that, Congress has to give you a remedy. So the way it works is the Constitution provides a right of action. But what's your remedy? Your remedy is provided by Congress. So for example, 14th Amendment, Section 1, I have the right to be free from discrimination based on the color of my skin or my national origin. So if I go into a restaurant and the owner says, are you Hispanic? And I say yes. And he says, well, then get the hell out of my restaurant. He's violated my Section 1, 14th Amendment constitutional rights to be free from discrimination based on national origin, all that stuff, right? But what's my remedy? My remedy would be 42 USC 1983, the Civil Rights Act of 1964. And Congress said that I can sue for emotional distress, any financial damages, attorney's fees, things like that. So Congress provided the remedy. So the Constitution provides basically the jurisdiction. That's what he's going at, the jurisdiction. And then Congress provides the remedy. So what they're saying here is, well, yeah, Section 3 of the 14th Amendment says that Trump is ineligible. But what gives you the cause of action? What gives you the right to bring this lawsuit? Congress never said that a fellow candidate can bring this lawsuit. Well, what they fail to realize there is that the U.S. Supreme Court has in fact found implied rights of action directly arising under the Constitution. There's a very famous case called Bivens versus 6 unnamed agents of the Bureau of Narcotics. And in that case, it was basically the modern equivalent of the DEA. They kicked down Mr. Bivens' door, raided his house, didn't find anything, caused about $16,000 worth of damage, right? It was concrete damage. Nobody questioned that. He has receipts for all the damage to the door and all that stuff and all the inventory. And so he turns around, he sues directly under the Fourth Amendment. And the Southern District of New York, the federal judge looked at it and it's just like the same thing that Lindsey Halligan is saying right now, which is like, well, the Fourth Amendment says you have the right to be free from an unreasonable search and seizure, but Congress never provided a remedy, and you're trying to sue them for $16,000 in damages, and Congress never said you could do this, so case dismissed. Right? I mean, sometimes these federal judges, I wonder if they even have a positive IQ and a working brain. It's like, guys, our founding fathers said we have a right to be free from unreasonable search and seizure by the federal government. And here you have the federal government kicking down a man's door, causing $16,000 worth of damages to his store. And you're saying, well, sorry, Congress never said what you can sue for or what your remedy is. Like, come on, turn your brain on for a second and look at the practical reality. So this went to the United States Court of Appeals for the Second Circuit. Second Circuit looked at it as well and just said, sorry, you have to have a remedy that Congress allowed. It went to the Supreme Court, and the Supreme Court, thank God, had their brains activated and said, guys, if we dismiss this case, we basically green light the FBI and the DEA and the CIA and God knows who else to kick down anyone's door, and they don't have any way to hold them accountable. It's going to render the Fourth Amendment worthless words on 200-year-old paper. We can't allow that to happen. That's ridiculous. Like, the American people shouldn't wait on Congress to create a remedy for the rights that hundreds of American revolutionary soldiers fought and died for, just so that, so I mean, think about that. There's a dead American revolutionary soldier on the ground, says, hey, you fought for this Constitution, awesome, but sorry, Congress forgot to pass a remedy, so we're kind of like shit out of luck. It's like, no, that's not the way it works. So the Supreme Court at that time looked at that and basically said, no, like, we're going to recognize an implied right of action, like, and they allowed his case to proceed, and he ended up collecting his damages, and rightfully so, because if not, you render the Constitution meaningless and toothless, effectively defanged the Fourth Amendment if that case had been allowed to uphold. Thankfully, the Supreme Court said no, and they allowed it to proceed. So for Lindsey, and I cited this in my reply brief, which again, Trump completely ignored in his final reply. He again obsessed about like, oh, he doesn't even have a donation link working on his website. I
saw that,
and, and I'm like, come on, man, is that the best you got? Like, because if that's the best you got, that's pretty freaking pathetic. And I know that people reviewing this aren't attorneys, but I can tell you from an attorney, and you can run this by any constitutional law perspective, that final reply brief by Trump was pathetic. It was sad. And it was a sign that they realized this guy figured it out. He knew exactly what to do to establish himself as a candidate. And I'm running for the presidency of the United States, and I will see Trump in New Hampshire, and I'm going to be on that debate stage. And I cannot wait because, well, I'll save that for the debate. He's going to be surprised because, he's really snappy, and, he likes to embarrass people. We have a lot in store for him. So,
and just so you guys know that we are live on Facebook. We were trying to be live on YouTube, but I was having some problems connecting the feed. And we will carry this as a premiere later. So we will edit and put and make it dynamic for you guys. But Facebook, you're seeing it now. But if you're the other feeds, will get it delayed. So sorry about that. Yes, and we have with us the U.S. 2024 presidential candidate, Republican presidential candidate, Mr. John Anthony Castro, and he's running for president, but he also have an active case, the Castro V Trump case, which was filed on January 6, 2023. And right now I had asked, he was responding to Mr. Trump's motion to dismiss, and he has a very powerful legal argument and response to Mr. Trump. Also, we know right now that there is a writ of mandamus that is which is a suit that is aimed at removing or recusing Judge Aileen Cannon, who is on the case, but apparently there is a conflict of interest. Yes, and we have, for those of us who are joining us, you guys might have missed that. When you listen to the rebroadcast, you will hear that. Okay, but you were giving us you were responding to Donald Trump's motion, and I think you were you talked about, so you have standing, you have rightness. You're talking about you will be meeting him in New Hampshire, and he said that you have not distinguished yourself from the public. Is that the relief you were referring to just now?
No, so that's the attack on rightness and sort of saying that I'm not a bona fide candidate. I'm not really running for office, and they were like trying to say that I haven't registered to be on the ballot in any states. Neither has Trump, because you can't file right now. Like, the filing doesn't open until November. So it's just kind of if that's your standard for who a candidate is, then Trump's not a candidate either. But
Trump is levying an attack against you, and he himself is not registered.
Exactly. Wow. So it's ridiculous, right? And it's just I get it, right? It's Trump's attorneys, right? They get paid to file a response. You have to file a response no matter how pathetic it is. And then they tried to misquote the Golden v. Zwickler case to try to say that the Supreme Court said that courts can analyze whether a candidate is real. That's not what that case said. And I even warned the attorney. I was like, you're getting dangerously close to being prone to sanctions, which we've already seen. One Trump attorney already got hit with $1 million in sanctions. And I said, like, you are intentionally misrepresenting that case. And that is an indefensible misrepresentation. There is no reasonable person that can interpret that case that way unless she's actually that dumb, which I mean, I don't think she is. I think she's highly intelligent. She just knows that she's grasping at straws and she has a losing argument. So that being said,
Yeah. Go ahead.
Oh yeah, yeah. It was a very weak and pathetic reply. If the judge and who knows, you're right, like Judge Allen Cannon doesn't care, right? She's going to abuse her position as much as she wants. But if she dismisses the case based on ripeness or standing, um, she's done, because that's going to get overturned like that on appeal. So, but she has a couple of options, right? Like she can do that, but now she risks that I'm going to appeal the case, consolidate it with the writs of mandamus, and then she's going to be at risk that she gets kicked off the case. The courts find that I do have standing and then send it back down, but then recycle it and put a new judge. And so she's going to lose control of the case. So I think if she was smart, she'd want to hold on to the case, go ahead and say, you know what? For purpose of the motion to dismiss, we have to accept it as true. So we're going to accept that he's a candidate, but we're going to get into the details of whether Section 3 of the 14th Amendment is self-executing. And they're going to have to, of course, argue that it's not, so that I don't have a cause of action, and then dismiss it on that basis.
Okay.
But then there's a risk with that too. Now it fast tracks that issue before the appellate court, the 11th Circuit, and then eventually also before the Supreme Court. But if I have standing, and the claim issue goes straight to the appellate courts, and they determine that Section 3 of the 14th Amendment is self-executing, then it gets remanded back down for a full-blown trial. At that point, I get to depose Trump and put him under oath. And that's something that the January 6th committee couldn't even do. And in my case, I'll be able to get him into a deposition. So this is, and we'll actually not even go there, because I'm just going to immediately motion for judgment on the pleadings to basically say, hey, look, the record is irrefutable. We know what he said. I don't need to get him in a deposition. And the thing is that I'm going to do that because I want to fast track it to the Supreme Court. So we're going to do what's called a motion for judgment on the pleadings. There's no factual issues at dispute. Trump knows what he said. But now it's funny. He put out a message on Truth Social. And a lot of people don't know why he said this. I know why he said it. He immediately started basically saying that on January 6th, that when he made those statements, he was talking to the innocent people that were just walking around, not the ones that were inside the Capitol. So he was saying, you know what I mean? And so then also, but I mean, it's like, how do you get around the fact that you were at a campaign rally and you said the January 6th defendants are being treated very unfairly, and we're going to have to look at pardons if I get into office? You know, he's going to try to say, I never said I'd give them pardons. That doesn't matter. It's aid or comfort. You're giving them comfort. You're comforting them in the idea that they might be, you know, executively pardoned for their crimes. And even if you suggest that as a possibility, that qualifies as comfort. So he's trying to wiggle his way out, you know, but he knows that the walls are closing in. And I hate to be blunt, but I want to be honest, which is that the attorneys at the U.S. Department of Justice suck. I am sick and tired of watching them try and fail miserably to hold him accountable. And it's because they lack strategy and they lack ingenuity. They think within a strict box, and you can't get them to think out of that. And it takes somebody like me, a renegade, a free thinker, to come in, come up with a plan and execute it flawlessly. And there's a lot of people out there that think like, oh, somebody has to be behind him, right? George Soros, blah, blah. First, I find that insulting, because it's like, you can't believe that a Hispanic man is the one that actually figured it out. And the answer is no. Like, if you look at my finances, you look at my company, if you even look at my background, I bumped heads with Georgetown and the dean there. I had beef with them. Like there's a lot of drama, pretty much. You know, I bumped heads with the Republican Party. I bumped heads with the Democratic Party. I bumped heads with a lot of people. Some people might call me a rabble rouser, a troublemaker, but it's good trouble. And so, but when I saw what happened on January 6, 2021, I made it my life mission that I am going to run for president. I'm going to challenge Trump, and I'm going to get it kicked off the ballot. And where DOJ and the New York Attorney General and the Georgia District Attorney, where they have all tried and all failed miserably, I will not fail. I've planned this meticulously. I'm flawlessly executing it. They're seeing it now. And now with Jim Trusty finally notice of appearance, they're finally realizing this guy is not messing around. He is going to have this. I mean, he is one step away from the Supreme Court right now, right? He's like, within 30 days, there was a writ of mandamus before the United States Court of Appeals for the 11th Circuit. And this is going to be fast tracked to the Supreme Court.
So I have some questions. So those of us, by the way, we were a little delayed. So people are just joining us on Facebook now. I have with me, welcome to the Castro V Trump series. And I have with me Mr. John Anthony Castro himself, the 2024 Republican presidential candidate, who is suing Trump and is the main plaintiff on the Castro v. Trump case, where he is suing Donald Trump as it's a civil action against Trump under the Declaration of Relief Act. Am I correct?
Yeah. So that's the other thing too, is that nobody knew exactly how to do this because there was all these debate among constitutional scholars. And I talked with a few constitutional professors of mine. I went to UNM, I went to Georgetown, I spoke with a lot of them. And they said, well, John, it's really complicated because if you sue him in state court, right? If you wait till the primary start, you sue him in state court, then even if the let's say Pennsylvania Supreme Court says, yes, he violated Section 3 of the 14th Amendment, the Trump attorneys can remove it to federal court because that's a federal question.
Yes.
And so then the Supreme Court could technically overrule them, or a lower federal court could technically overrule them. And so they were just like, it's really difficult, and they couldn't figure it out. And I was the first one that just said, screw it, I'm going to sue the FEC. We'll see what happens. And then after I'm done with that, I'm going to sue Trump and see what happens. Everybody else was so afraid of like making mistakes or like, oh, what if I get it wrong? It's just like, look, man, we can stay here talking all year and be talking heads, like all the talking heads on TV that don't actually do anything, or you can go out there and get your hands dirty. And I'm going to be the one to do it because apparently, I'm just going to be really blunt, they're too chicken shit to do it. So I was like, I'm going to do it myself. And so, and just for viewers out there, the reason I'm dressed normal right now is because I'm not a puppet. I'm not here to be polished and everything. I'll be polished when I'm in New Hampshire, right? When I'm
man, you know me.
when I suit up, believe me, like my suits are custom tailored. They look really nice. But like right now, like you're seeing me casual because this is who I am. And so yeah, I decided to bring this, and Trump's lawyers are now realizing the full gravity of this, and they realize the existential threat this is posing to his candidacy. And what I'm doing here also is I'm charting the path. Number one, it's going to go to the Supreme Court, and I can tell you right now we have the votes. It's going to be 5-4. We don't know who the fifth person is going to be, but we know it's going to be 5-4. Actually, probably. By when do
you think it will go to the Supreme Court?
October.
Oh wow, guys! Are you listening? By October, the Castro v. Trump case probably will make it to the Supreme Court by October.
Will be before the Supreme Court,
and you guys will get a chance to subscribe to the show, guys. At least once every other week or so, we will be here with Mr. Castro all the way up until the U.S. Supreme Court on this case. But sorry, I was interjecting because I know people are watching now and want to know more. But continue, sir.
Yeah, absolutely. So yeah, I mean that's pretty much where we're at right now, which is that the Judge Cannon's about to rule on the motion to dismiss. And
when is that going to happen? When is
within the next 21 days? I think about maybe 2 more weeks, because generally they rule within 30 days. She could decide to try to pocket veto it and not do anything, but we already have a plan for that as well. But
wait, what is pocket veto?
Oh, sorry. Pocket veto is an analogy. She could basically choose to just sit on this forever and not make a ruling. But we can file a writ of mandamus on that as well. So and that would only further illustrate, her biasness in this case, or her bias. So that being said.
But you are staying, but also you file an emergency stay, which prevent her from ruling right now on dismissing.
Correct. Yeah. We asked the 11th Circuit to do that. They haven't done it yet. But very oddly, on Friday, Jim Trusty submitted a notice of appearance. So Jim Trusty is Trump's appellate lawyer. He's a lot more crafty. He is the only Trump attorney that has former experience at the U.S. Department of Justice. But I can tell you right now that we overestimate the intelligence of DOJ attorneys. A lot of people like to put that on the resume and like, oh, I was an attorney at the U.S. Department of Justice. I might consider hiring somebody like that at my firm, as a junior attorney maybe. But to me, that doesn't add any credibility to a person's resume. So that being said, Jim is now officially on the 11th Circuit writs of mandamus cases, both of them. And I emailed him on Friday and I let him know, like, hey, just FYI, there's also a DC Circuit case if you want to file a notice of appearance there. But I don't expect him to do that because, the idea there is, it could end up leading to a lot more legal bills for Trump. And I don't know if Trump would want him to do that because all these lawsuits, all these legal defense, it is draining Trump financially. It's depleting his financial resources, right? And he's using the PAC money to pay it, and he has a lot of that PAC money. But to get a vote,
he didn't take you seriously. I'm just thinking about it because he had one of my fans on YouTube said, I don't remember the name of what was the attorney that had initially said that you didn't have standing initially when you had just filed the case. He had
Lindsay
not,
Halligan.
so is she still on the case?
Yes,
Okay.
yes. Yeah, so Lindsay Halligan, sorry, is the lead attorney in the federal district court level.
Okay.
And then Jacob Grubman, he's an attorney from DC. It's weird. He does like online gaming sports law, so like Vegas things. I don't know. So that's all Trump can apparently scrape from the bottom of the barrel. So he filed a notice as well. He's really the one drafting everything, I believe, for Lindsay Halligan. I basically threatened to report them for the unauthorized practice of law, and then he immediately filed a motion for pro hac vici status, and the judge instantly granted it, which basically says, although you're not a Florida licensed attorney, we'll let you practice here. So she gave that to him, but not to me. but whatever.
Yeah.
So that being said, after that, though, Lindsay Halligan is not licensed to practice before the 11th Circuit. And so that's why she couldn't file a notice of appearance when I filed the writ of mandamus. So that's why Jim Trusty had to step in and file the notice of appearance in the 11th Circuit. Because if not, Trump would not have an attorney before the 11th Circuit, right? I mean, that would be embarrassing for a former president to not be able to scrape up an attorney to do that. So that's kind of what's going on right now. And then there's the DC Circuit case dealing with, whether to expand the FEC's power to determine eligibility. So those are all the various cases and all the avenues that I am fighting Trump right now. DC Circuit, 11th Circuit, federal district court level.
Yeah.
The judge is going to have maybe about 2 to 3 more weeks. Now, the reason that Judge Cannon is going to take her time is because there are a lot of political angles to decide here. Again, if she dismisses it based on standing, she is going to basically guarantee that it's going to get appealed, consolidated, and she's going to likely get cycled off the case, and then it's going to get remanded back down. And now she can't protect Trump. But if she agrees and says that I do have standing, that undercuts my argument that she's biased, right? Because now she's shown, hey, I'm not biased. I found that he has standing. But I'm going to attack his Section 3 of the 14th Amendment argument. That would somewhat make it more difficult for the 11th Circuit to find that she's biased. But it would also fast track the Section 3 of the 14th Amendment argument. And Trump's legal strategy has and always will be delay, delay, delay. Right. So he'd probably want her to rule on the standing issue, but she'd probably be advising against that. Like, right, we know they have back channel communications, right? Yes. I mean, we know Kennedy's talking to Trump people, probably meeting them at midnight at Mar-a-Lago, by the golf course before the sprinklers turn on. So that being said, I mean, we know that they're strategizing on this and they're trying to figure out what's the best way to handle this. But it's like trying to stop a comet coming to Earth. It's like, guys, I already have contingency plans. Whatever they decide, it doesn't matter. This is going to the Supreme Court. And it's going to be fast tracked. So whether they like it or not, it's going to happen. And if I had to project, it would be by October, which is perfect. And I'll tell you why I know the Supreme Court's going to take the case. And there's the same reason why the Democratic leadership wants Trump to be the nominee for the GOP. Every hypothetical that they run in computers doing these analyses, Biden v. Trump, Biden wins. Biden v. DeSantis wins. So they do not want DeSantis to be the nominee. And I know that's a risk that I'm running, but we cannot allow Trump to get this close to the White House again. So, it's just like, hey, Democrats, instead of focusing on trying to undercut them, just try to focus on doing better, run the economy better, get this banking crisis under control. All you have to do is not burn down the country and Biden will get reelected. But yeah, we'll see. But the idea here is that we know the Supreme Court wants to close the chapter on Trump. They want to pave the yellow brick road for DeSantis. And this case gives them that possibility. They can take this case. Gorsuch and Kavanaugh can show that although Trump appointed them, that they can be, neutral. And one of them is going to turn, right? Because they want to demonstrate that they're not loyal to Trump, that they can rise above politics. And that's their one chance to do it. And I think it's going to be Gorsuch. So that's how I think we're going to get the 5-4. So Gorsuch crosses over and basically says, you know what? I want to also seal the deal as well and prove that I have absolutely no loyalty to this man, even though he gave me a lifetime appointment to the Supreme Court, and officially chop him. So that would also guarantee and increase the probability of a GOP president being elected in 2024. So and I'll tell you right now, the GOP establishment is supporting this case, including Fox News. They do not want Trump to get reelected. And they're also trying to force a rally behind DeSantis. And again, this case provides that. So this case is making for odd alliances and bedfellows.
Yes, this is.
Yeah,
definitely.
But again, it's we got to focus on one step at a time. So I also do not want DeSantis to be the Republican nominee.
No, we do not. Listen, I heard that DeSantis was in Philadelphia. The pastor at Enon Apostolic, a very major church in Philadelphia, in Pennsylvania, very important church, very influential church. I understand that they are they are very upset that DeSantis came to Philadelphia and gave a speech at a union, one of the unions here. This is Philadelphia, about 46% African American, and we have a lot of Black academics. Philadelphia that had the railroad, the Underground Railroad. He came to Philadelphia, the guy that's trying to black academic books, black books, critical race theory. We're against that. And I'm hoping that I'm hoping that. Well, I don't want to sound too political on this show.
No, I get you, but no, I mean, in my book, DeSantis is a fake conservative. He's not, right? He's one of those Christofascists that are basically trying to hide behind a fake racist version of Christianity to try to mask their fascism. So yeah, it's fascism masquerading as Christianity and with a sprinkle of conservatism. But what they're doing is they're adapting the cultural wars of the conservative movement, and then trying to basically militarize that, and use that as a Trojan horse to push a fascist ideology agenda. So that being said,
one question. I was going to wrap up soon, but Mr. Trump said that on Twitter and on ABC and so on. The several news agencies are reporting that he's saying that even if he were to be indicted or held responsible for January 6th, he is not giving up. He will still run. He will still be out there running.
I mean, he has to, because he's either out of prison, and he knows that in his mind, this is what Trump's thinking. If I continue campaigning and I get elected president, then they can't put me in jail. And it's just like, dude, that's not how it works. Like, I'm going to get you kicked off the ballot in Pennsylvania, Georgia. I can tell you this right now, 100%. Pennsylvania, he's off the ballot. Why?
Yeah.
Because Democrats control the Supreme Court. He's done. Arizona, we got the end. The Secretary of State there, he has the unilateral power already granted to him by the United States Court of Appeals for the Ninth Circuit, or U.S. Court of Appeals for the Ninth Circuit, to kick Trump off the ballot on his own. But either way, we'll get it through judicial action. So Trump is off the ballot in Pennsylvania. He's off the ballot in Arizona. We're going to get him kicked off the ballot in Georgia as well. And then next, we're focusing on Wisconsin and Michigan. Michigan, we also almost there. Wisconsin, though, we got that down. So that's it. He can't get the critical swing states that he needs to win to get to 270. So it's impossible. He doesn't realize that. Yeah, of course. And of course, he's going to fight tooth and nail. Right? He thinks that he can beat me. But the problem is that Trump has never run into somebody like me, which is that it's a mix of a legal strategist with somebody that has been boots on the ground. I used to be a union organizer, by the way, for those that don't know. I trained with the United Steelworkers of America in Pittsburgh, Pennsylvania. I'm a certified union organizer. So I've been down on the streets, right, with union, helping organize city workers, sanitation workers. I've been out there getting my knuckles bloody with them. So I know what it is to be a political fighter. And not only that, but having that knowledge, and that's what I was doing when I was 18, 19 years old. Having that knowledge very young in life, not only that, but also military training. And then on top of that, you sent me to Georgetown. I learned everything about the law. That's what created the perfect storm here for me to come after Trump. So Trump has never dealt with somebody like me, right? He's always dealt with those guys that, the polished, they're giving the speech like Marco Rubio, right? The teleprompter goes off and then he just stares at the camera like, I don't know what to say, guys. Somebody somebody puppet me or something. And again, it's because these guys are all fake. They're all controlled by their donors. And I'm not. I'm a free thinker. And I know exactly what I'm doing. So Yeah, it's going to be fun. It's going to be wild.
Oh yes, we're looking forward to it. And guys, just so you know, I mean, we won't give you too much now. We're gonna wrap up now. We've been on the show. We've been on here for about an hour, a little bit over an hour, and we're gonna be doing this as much as regularly as possible. And whenever there are updates, we will. Myself and Mr. Castro will come together, and we're doing the Castro v Trump series. So you will be updated because one of our fans said that why is it that people are still not following the Castro v Trump? And many people want to know about it. What's going on? You know, how do you respond to her? And she might be watching. Probably be watching later.
This is what I love about the internet age, right? Like we used to. I mean, if it's not on CNN, it's not real, right? You know. But now we have the internet, and the thing is that look, the mass media here. There's a bit of corruption. I don't like criticizing my friends in the media because I don't want to alienate them, but I need to be honest about it.
Yes.
Again, remember what I told you earlier. The leadership in the Democratic Party wants Trump to be the nominee.
Yes.
They don't like my lawsuit. The Democratic leadership does not like my lawsuit. They want Trump to be the nominee. So they don't want me to challenge it because they're like, dude, you're making it harder. If it's DeSantis is younger, he's more handsome. His wife looks like freaking Jacqueline Kennedy. He has a better shot at actually winning the presidency. Yes. And then you have somebody that's just like Trump, but is actually intelligent, you know, and will actually be able to get some of these things done and really push a fascist ideology. So that is the reason why a lot of the left-wing controlled media doesn't want to cover this. Now, as far as the right-wing media, as far as Fox News, they're in a bit of a catch-21. Like, do we cover his lawsuit, but then he's attacking us also? Right? Because I'm criticizing Sean Hannity and Tucker Carlson. I'm rooting on Dominion, bankrupt Fox News. Like, I want to see them finally pay for all their lies. So I just said that, right? So you think Fox News is going to bring me on their show? Of course not. So now you have the conservative wing that doesn't want to cover me either. So it's no wonder why I'm completely shut out of the media. The liberals don't want to support the lawsuit. The conservatives are like, well, I mean, he's criticizing us too. So it's like the enemy of your enemy is your friend, but not really. So if you want to know why the mass media is shutting me out, that's the reason why. They're both playing loyalties to their own sides for their own political agenda.
Yes.
So I'm being iced out. Now, here's the thing. I don't give a damn whether the media covers this, right? I'm in this because whether the media covers this or not, if I'm successful, I'm carving out a page in history for myself. And it might just be a footnote, but I'm going to be there in that footnote. And I'm going to be an integral part of American history in holding a former president accountable, right? Some random attorney from Dallas, Texas is the one that finally held his feet to the fire and held him accountable. And so here's the thing. They can ignore me all they want. They're not going to be able to ignore me when the United States Supreme Court rules in my favor. So that's that. They're going to be forced, whether they like it or not. They will bend the knee. They will cover this. Give it time. But watch it here with Renaldo show, and then you'll be able to say, I was with them from the beginning.
Definitely. And it's the Castro v Trump show, actually. Castro v Trump series, and featuring John Anthony Castro, who's running for president, the president of AI Tax, a company that's valued at $187 million. A young man, a powerful, erudite gentleman that he will tell you he wasn't born in money, but here he worked hard, and now he's a multimillionaire. 2 companies, graduate of Georgetown University, graduate of Harvard University. Let me tell you guys, this is a young man who you should check him out. Don't be narrow-minded or myopic, okay? Just expand your thinking, guys. And I appreciate what you're doing. We support what you're doing, and we will continue to pray for you. And by the way, before we wrap up, just so you know, I thought about something with the FEC. Because when people make legal determinations, sometimes it becomes the law of the land, or it becomes a precedent. This thing about the FEC is quite interesting, because the ruling about we would think that the FEC did more than just regulate financing. I believe that they do more than that. But the thing is, if the judges, if the courts are going to rule that they only regulate financing, that means going forward they can be challenged for acting outside of their jurisdiction based on this particular ruling, saying they are only supposed to regulate financing and nothing else.
Yeah. Yeah.
Okay, that's quite interesting. You get the last word.
Yeah. So we should get an update within 2 to 4 weeks, possibly less, but my guess is that it'll probably be another 2 to 4 weeks in full, because as of right now, Judge Cannon has issued paperless orders for everything, right? Denying my electronic filing, denying the recusal, granting the prohibition status for Jacob Grubman. And it's this level of disregard, and looking down and having her nose up in the air. When a paperless order is a really rude way to just basically dispense with something as like almost like frivolous. But you can't do that with a motion to dismiss. So she's going to have to sit down and very carefully draft an opinion that she knows is going to be scrutinized by both the 11th Circuit and the Supreme Court. I'm going to be really blunt. She is simply intellectually outmatched. I am more qualified to be a federal judge than she is. If you look up her transcripts, if you look up the where she went to school, everything, it's not up to par, right? She got that job by basically kissing Trump's ass, and she got then nominated to sit on the bench. And the reason why she's continuing to protect him is she probably got promised that if Trump retook office, that he'd probably try to get her on the appellate court or the Supreme Court. So she's a Trump brown-nosing sycophant. We all know that. She's going to try to rub her two IQ points together to try to come up with a good order, but it's going to fail. So it's going to be interesting. So I think the next one, the next episode should be definitely when she rules on the motion to dismiss and how to draft that. Yeah. And then from there, we'll of course appeal to the 11th Circuit, and then we'll have another episode to kind of go over that and discuss all the dynamics of it. But the thing is that the 11th Circuit already proved that. See, the thing is that the 11th Circuit, they're old school Republicans. Yeah. You're talking about Bush senior Republicans, Reagan Republicans. Yeah. So they don't like Trump. They're like me. They're OG conservatives. Yeah. And so my guess is they're going to rule in my favor. And that is when it's going to create a media firestorm, because they're going to remand it back down. And who knows, at that point, Trump could be the one that if there's an unfavorable 11th Circuit opinion, he appeals it to the Supreme Court, which he likely will, right? He always does that. So it would be very uncommon or uncharacteristic for him to not do that. So it could actually be Donald Trump who actually fast tracks this before the Supreme Court. But we'll have to see. But either way, we'll have a very substantive update within 2 to 4 weeks.
4 weeks. Okay, great. Okay, guys, you got that, and thank you so much. Did by the way, Judge, who appointed Judge Cannon? Was it Mr. Trump?
Yeah, it was Trump. Yeah.
Oh, wow. Yeah. I mean, are we gonna? Is there any? Are we gonna? I mean, what do you think? I mean, this issue of executives appointing judges, and then now that you find that executives have immoral or immoral issues. I mean, executives also commit crimes. Are we going to read about this whole law of executives appointing judges? That is a conflict of it. They said it's not a conflict of interest because judges are above that, but we are human beings.
Exactly.
It's a talking point.
So yeah, we didn't take that bait either, because I knew that argument has failed in the past when somebody tried to say like, oh, well, this president appointed this judge, so therefore they're disqualified. It has to be more than that. The Supreme Court's already ruled on that too. So,
yes, did.
But we all know, like what you said, we all know the reality. But of course, the judges are like, well, we don't want our judgment being called into question just because this person nominated us. Okay. So I get that. But that's why our argument focused solely and squarely on that it would give the appearance of bias. Okay. So rather than saying she's actually biased, which we don't have evidence, right? Because she's never publicly stated it. And an adverse ruling isn't in and of itself evidence of bias, even though the appellate court said it was abusive and unconstitutional. But judges screw up sometimes, right? So that's why our argument was very carefully, narrowly tailored to saying, like, look, we can all at least agree it gives the impression of bias. And on that basis alone, recusal is mandatory.
All right. Thank you so much. And on that word, we will end. But just to wrap up, just so you know, guys, please support Mr. Castro and his campaign. He has a website. You can go to Castro John. It's johncastro.com.
Yeah, johncastro.com.
I was about to say John.
And Good news is that fundraising goes live on Friday, so we'll be able to start raising campaign funds. I mean, we were already doing campaign funds, through private events, but yeah, now we're going to really unleash and we're doing that in preparation of the media coverage, because we know that once the mass media is forced to cover this story through a successful 11th Circuit reversal, that's going to draw a lot of attention. At that point, I'll be able to then raise a lot of funds. But actually, well, I got a surprise for the next meeting. I have a surprise for everybody. But
thank you so much. Yes. So please support Mr. Castro. And of course, you can subscribe to the show for free and you'll get notified when the show becomes available. It's https://anchor.fm/the Neoliberal. We are now in over 36 countries on every single audio and streaming service. We are everywhere, guys. There is nowhere where we are not, because you know why? We took a page out of Mr. Castro's book, who has been advising us indirectly. He says we must leverage technology, and we are leveraging technology, and we are everywhere. Thank you guys for supporting us and for believing in the Neoliberal Corporation. Continue to subscribe, visit us at theneoliberal.com, and walk good. And we will end on, of course, a note of prayer, since I'm a man of faith. I thank you for this great time, Lord. And some people worship Buddha, Allah, whatever people worship. We do not judge. But all we say is thank you, ultimate, for this awesome time and this amazing gentleman and what you're doing in his life. Give him wisdom, give him strategy, empower him, and grant him favor. We tell you thanks. Amen and amen. And I hope you become the next president of the United States of America. We are rooting for you because we like your platform and what you're about. Okay?
Yeah.
Take care.
Have a good night.
Yes, sir. Take care. Bye-bye.
All right, bye-bye.
Bye.